Yes, hello, my name is Deborah Fosbrook. I'm co-author of Contract and Copyright Drafting Skills. Today I'm going to talk about the subject of royalties. I'm not going to cover what actual percentages you should get in royalties, but I'm just going to cover in general the issues that are involved and that you should have in mind when you're drafting any contract which involves any royalty payment whatsoever. So what is a royalty? A royalty payment is literally a percentage of money that you're being paid in relation to either a right or a product, a sale of a product, or some other form of exploitation. So quite normally within merchandising agreements, film agreements, different types of agreements that you get, what happens is different percentage royalties are listed in relation to either actual different formats. So you might list, for instance, television, cable, satellite. You might list hardback, paperback, publishing. So you might either draw up percentages which relate to specific types of known use, or you draw it up by relating percentages to different forms of technical exploitation of rights. So you're not directly relating it to a format, you're relating it to a form of exploitation of rights. So for instance, you might have a percentage which relates to the sale of a merchandising product like a toy, and you're very specifically mentioning that toy and the sales of that toy. Or what you're doing is not mentioning a percentage in relation to a toy, you're relating it to the toy market or forms of exploitation of a character on a whole range of different products. So when you talk about royalties, you can't just say, oh, this is the royalty. It is very much connected to other forms of drafting within an agreement. So the consequences of not drafting it properly may mean that you either receive very little money or your expectations are never fulfilled. So the royalties will be a percentage, will be on a variety of things. It may be a percentage of gross receipts, it may be a percentage of sums received, it may be a percentage of net receipts. There's a good argument, if you're getting 10% of net receipts, that is not the same as necessarily the same figure as getting 5% of gross receipts. So when you're working out actually what financially you're going to get, you need to do the mathematics. You need to actually, when you're in negotiation, go through the formula of working out what potentially a product would sell for. Are you going to get a percentage of sums received from the retail price, the wholesale price, the recommended price, sums received? So you need to understand what gross receipts are, what net receipts are, and what sums received means, because there are some contracts where you think, great, I'm getting a percentage, I'm getting 10% of gross receipts, but when you look at the gross receipts clause, that is not actually total receipts, because within the gross receipts clause you find that the licensee is entitled to take off reproduction costs, marketing costs, clearance costs, and all sorts of other things. So don't be misled by thinking, by the word that someone's attributed to a definition. You actually have to read the clause and say, what is this person taking off before I get my percentage royalty? What sums are they deducting? So, for instance, they may take off commission, they may take off agents' fees, they may take off shipping costs, and all these figures are going to have an impact on the money that you get at the end of the day. So, the other aspect of royalties is you may find, for instance, that a licensee or a distributor will want the right to withhold a certain amount of money against future returns. They may want a clause in that says, well, you're not actually going to get paid any royalties if stock gets destroyed by fire, flood, if we give away promotional copies, or if we give away promotional products at an exhibition. So, you know, you've got to think in terms of the financial consequences of royalties, which leads you into how do you get paid, who is the royalty going to be paid to. The contract should specify who the royalty is going to get paid to. So if it's going to get paid to a company or an agent who is receiving the money on behalf of an individual, for instance, you know, if you were drafting that contract, you would want the person who's authorising the agent or the company to receive the money on their behalf to accept that once you've paid that money, if that company or agent disappears or, you know, is fraudulent, that you as the licensee are no longer going to be responsible for additional royalty payments to compensate them. So that's another aspect of royalties. In terms of looking at payment of royalties, you also have to look at it in relation to how long the payment will be due and what other rights may be created in the future. So if you list all these royalty percentages in relation to different forms of exploitation or different formats, but you don't make any provision as to what happens when a new format is created or a new form of exploitation comes into existence at a future date, you may find that you're not entitled to any royalty whatsoever. So you need to put in a clause which says that if any new rights are created in the future, or there's any new developments, that there will be negotiations for a new royalty payment, or that you will, you know, the parties could agree, for instance, that there will be a fixed percentage royalty for future situations. The other aspect is that, you know, royalties need to be accounted for. So you need good, solid accounting provisions. You need the right to inspect the records of a company. And if there's serious errors, then you want the right to have any costs of an accountant's fees paid for. You also want to have the right to have the payment made on a regular basis. So you want it specified in detail, the method of payment that's going to be made to you, the means by which payment is going to be made, and to whom payment is going to be made. There are other costs which affect royalties, which often get forgotten about. Say, for instance, you've got a contract, but there's a sub-licensee, a sub-distributor. Well, in the process of money getting transferred from one business to another or one territory to another, there are going to be bank costs, there are going to be currency conversion charges. Now, you need to sort out who's bearing the responsibility for those. And if you don't want those deducted before you even get your royalty payments, then that needs to be specified in the agreement. So you can't look at royalties and royalty percentages in isolation. You have to look at it as in relation to other clauses within the agreement. The other aspect of royalties is how long are you going to continue getting paid for? You know, if you've got an agreement which is for a 5-year license that you've given to someone else, well, you don't want them to have the right to stop paying you your royalties after that contract has expired or is terminated if they're still receiving money. So you need to address that issue, that payment will still need to be made while money is being received by them, and not avoid it, because otherwise they're going to be arguing, well, the contract's terminated, therefore no more royalty payments are due, or the contract's expired, therefore no more royalty payments are due. So the accounting provisions in relation to royalties and the control of the money is crucial. And you know, you may even go further than that. You may even specify where the royalties should be held before payment is made to you. So you may set up an account because you don't want the money from those royalties mixed with other funds with which that business is dealing. So you need to analyse not only the percentage but the flow of money within the contract.